Hi, I'm Larry Smith with Legacy Transitions and your host for today's topic. Probate no more, charting a course to quick and painless asset distribution. Before we jump into today's topic, be sure to hit the like and share buttons and also click on the bell notifications. That way you'll be sure not to miss any future episodes. Now on to today's topic. When is probate not necessary? So probate is the legal process through which assets and the estate of the deceased person are distributed among the beneficiaries or heirs. When probate is common and necessary step in settling an estate, there are instances where it may not be required. Understanding when probate is not necessary can be crucial for individuals in estate planning and can save time and resources for both the deceased estates and the heirs. Number one, small estates. Probate is often not necessary for small estates. Now, the definition of small estates varies by jurisdiction, but generally it refers to estates with a total value below a certain threshold. In many places, if the estate's value is below a specified amount, it may qualify for simple probate procedures or may exempt you from probate altogether. This is because the cost and time associated with probate may outweigh the benefits for smaller estates. For example, here in Denton County, a small estate affidavit reads as follows. The appraised value of the estate is less than $75,000. Homestead value or other exempt property is not counted. Big deal. So that means a lot more estates are being probated in this county that is not necessary. And this is a key component. You need to know the small estate affidavit for the state of Texas if you're here in Texas. And the next thing is no one has applied to become an executor or administrator of the estate. And the total assets exceed total debts, not including the homestead or exempt property or any other debts that may be associated with the homestead or exempt property. Next one up, number two, assets held in trust. Assets held in a living trust are typically not subject to probate. A living trust allows individuals to transfer their assets into a trust during their lifetime with a designated trustee managing and distributing the assets according to the terms of the trust document. Since the assets are technically owned by the trust, they do not form part of a probate estate, and probate proceedings are not necessary for this transfer. This has to be my favorite way in which to hold assets. As you can see, it avoids probate. Can you imagine the relief it is for your family members to know they will not have to endure probate? Number three, joint ownership with right of survivorship. Property held in joint tenancy or tenancy by the entirety with the right of survivorship automatically passes to the surviving joint owners upon the death of one owner. In such cases, the property does not go through probate because ownership is transferred directly to the surviving co-owners. This can apply to various assets, including real estate, bank accounts, investment accounts. Please note, if you're married, that your real estate agent should be making sure that you take title as joint ownership with right of survivorship when you take title. This is very important. If you would like to know more about this topic, then just reach out to me. Again, my contact information is in the channel description. Number four, beneficiary designations. This is a big one. Certain assets such as life insurance policies, retirement accounts, payable on death deeds, transfer on death deeds, even bank accounts, a biggie, allow individuals to designate beneficiaries. When a person with such assets passes away, the proceeds go directly to the named beneficiaries immediately without going through probate. This streamlined process ensures a quicker distribution of assets and avoids the delays associated with probate. One real important note here is to be sure that you add your spouse and possibly one of the heirs to the account. I've seen heirs stressed out because of the money required to go through probate and the length of time, all because they weren't listed as a beneficiary on the bank account due to the length of the probate process. Number 5, community property with right of survivorship. In community property states, married couples can hold property as community property with the right of survivorship. This means that when the spouse passes away, surviving spouse automatically becomes the sole owner of the property without the need for probate. Community property laws vary by state, so it's essential to understand the specific rules in relative jurisdictions. Please note, if you live in the state of Texas, that Texas is a community property state. So, while probate serves as a vital role in ensuring the orderly distribution of an estate, there are situations where it's just not necessary. Small estates, assets held in trust, joint ownership with the right of survivorship, beneficiary designations, and certain community property arrangements are examples of scenarios where probate can be avoided altogether. Recognizing these exemptions is crucial for effective estate planning and can help individuals and their families navigate the complexities of settling an estate more efficiently. Seeking legal advice and understanding the specific laws in one's jurisdiction is always recommended, and it helps you in determining whether probate is necessary in any given situation. Guys, that wraps up today's topic, probate no more, charting a course to quick and painless asset distribution. As always, feel free to reach out to me about this topic or any other challenge you may be having in probate. My contact information is in the channel description. Again, thanks for tuning in, and until we meet again, happy trails.